With Justice, the new informative, educative, and thought-provoking program is what you need to keep abreast with law and politics. This exciting and truly refreshing program is anchored by Justice Madafuro, a solicitor.
Ladies and gentlemen, it's been a soul-searching discussion here with my colleague. We've been dissecting sole responsibility under the immigration rule, those under 18 and those above 18 years of age as well.
Law Simplified with Justice understands that law is a powerful driver to human behavior. It is therefore poised to simplify the law and get you to take action.
We'll bring it to your doorstep and simplify it the way that you will understand.
Contact Justice by calling 07931 727 597 or email lawsimplifiedwithjustice@yahoo.co.uk. Law Simplified with Justice, bringing the best to the audience.
Hello, ladies and gentlemen. I welcome you back again to this exciting episode or a section of this program, Law Simplified with Justice. As you all know, I'm your host, Justice Madafuro, and I'm a solicitor. Today in this program, we have yet another interesting topic to discuss with you today, and we will implore you and ask you to sit back and relax and watch this program today. A program that is very educative and informative that will assist you and your words and your friends and whoever that needs this advice. Today we will be discussing discretionary leave to remain in the United Kingdom under the immigration laws. I repeat again, today's topic will be discussing discretionary leave to remain in the United Kingdom. This topic is very important and timely as well, and this is why we have thought it fit to bring this topic back again to discuss with the audience. We'll be giving our opinion on this program, and as you all know, whatever we say here is just the opinion of the guests on this program. You should not rely on them, but rather you must seek legal advice before you can act on whatever you hear on this show. Ladies and gentlemen, as you also know, this program will assist you if you need any advice in any areas of law, immigration laws, criminal law, employment law, contract law. Contact the numbers and the email on you can see on the screen, and we're very happy to assist you, get you to the office and take full detailed instruction from you and then advise you and give you tailor-made advice in respect to your case. But however, I will need to point on this program and make it very clear that once you call us and you want to come and see me in the office, there is a consultation fee to be paid. It's important I make sure I mention this to the audience as well. So, ladies and gentlemen, going straight away to discuss this matter today, discretionary leave to remain, as you can see on your screen, is a very important topic under the immigration law. To discuss this with me is Mr. Matthew Owolabi. Mr. Owolabi is a solicitor. You're welcome to the show, Mr. Owolabi.
Thank you for having me.
I will refer you as Matthew, and I prefer, I'm more confident to call you Matthew. I'm sure you're happy with that.
That's fine.
Okay. Ladies and gentlemen, as I said earlier, we are discussing discretionary leave to remain in the United Kingdom. Now, there are different types of application one can lodge in the United Kingdom to remain here in the UK, as long as you are not a European citizen. There are some of applications you can lodge here, and those are those within the law and those outside the law. And today we are discussing primarily those that are outside the law, and in that case means that there are certain people who can apply for this. And you may want to know, am I qualified to apply for discretionary leave to remain? Yes, you may be entitled to do so. But we will discuss and throw more light to it, and then thereafter we can take your comments. And remember that the numbers you can call us after the show is on the screen, and the email is also there. Once you call me, and I will get you to get to the office, take detailed instruction from you, and advise you appropriately. Now, let me start with Mr. Owolabi, Matthew, in this situation now. Now, this is discretionary leave to remain. What is it?
Discretionary leave to remain, as its name implies, is leave granted outside the immigration rules. Of course, people would make an application for example, say an application for asylum, and ordinary applications for leave to remain in the United Kingdom. Now, that application may be refused. However, the Secretary of State must pay attention to certain areas of law that do not directly come under the particular part in which that person has applied. So, for example, someone has made a claim for asylum. That application is refused because they do not qualify under the asylum rules. But the Secretary of State considers that there are human rights factors in this case, or that there are reasons why this person should not be removed from the United Kingdom. and that person doesn't qualify for humanitarian protection, the Secretary of State may go on to grant what is known as discretionary leave. As the name implies, it is granted at the Secretary of State's discretion. Of course, it may be policy-based in the sense that the Secretary of State is acting out on the basis of policies that he or she has made herself. However, it is still granted at the Secretary of State's discretion. So it's simply discretionary leave, as the name implies.
As the name is implying, okay,
That's
obviously,
correct.
discretionary leave. You made mention about applications that are those done, obviously, granted when a person makes an asylum claim. And then that is what is called the protection aspect of it.
That's correct.
Yeah. Then, for the purpose of this application, to those who have not applied for asylum, but they wish to make an application under the this rule or this policy which we're talking about today. Now, that comes under the non-protective, in this instance, non-protection cases here. And I want to dwell on the non-protection cases, which is the discretionary leave to remain or the non-protection scheme. Now, who are those that will be qualified to make this application?
The general point is anyone is qualified to make an application, and the Secretary of State does have a duty, whether it is pointed out to her or not, to consider the human rights factors in every case. So
yes.
Anyone is entitled or able to make an application which would subsume the discretionary aspect of the Secretary of State's consideration. So it's an application that is open to everyone, whether you've been in the UK for 1 day or for 10 years or for 15 years, whichever point you make.
That's a very key important information here. This application is open to everyone. That's a very important thing for you to take out from this program. Discretionary leave to remain in the United Kingdom's application can be done by anyone else. Anyone at all. So if you arrived in the UK today, you can make the application. If you've been here for 1 year, 2 years, 3 years, 10 years, as Matthew have said, you can make that application as well. Now, we're going to go into a little bit details in terms of what are the requirements for this. And so, as you rightly heard, you can make that application. So if you're considering it, or your friend, or your neighbor, or your family friend, or anybody at all whatsoever, get in touch with us. The number is on the screen, and we'll advise you what that it takes. Let me, Matthew, you said something about anybody can apply this, and then under what circumstance can one say, I want to make this application? Because, you know, most people out there be ignorant of the fact that, yes, they have been informed they can make this application, but on what basis?
Right. Let's be clear. It's not like we're recommending that people go out there and, you know, simply say, oh, I want to apply for discretionary leave to remain. The general idea that we are trying to put across is someone qualifies under the rules in the first place. Then, I mean, if your clients, if anyone comes to see you, you're looking at that point, and if they don't qualify, then you're looking at circumstances outside the rules under which the Secretary of State would consider that application and may then grant discretionary leave to remain.
Right.
Now, discretionary leave to remain itself does not exist within the rules.
Yeah, that's correct.
It's a question, it's always dealt with outside the immigration rules. So you asked for examples of, you know, circumstances in which that would kick in.
Absolutely.
Because
Your
that's
opinion,
the point
what do you think that is?
Right. So let's take, for instance, a new case that's come out now, which actually now brings European Union law into a bit, at present, into a bit, it's a bit of a muddy water right now, in the sense that the Secretary of State can actually look at discretionary leave or look at the regulations for parents of British citizens. And in this case, we're talking about the judgment known as Zambrano, which we were discussing earlier. Now, it used to be the case that if someone was in the, let's say a woman was in the United Kingdom, has a child, and that child, by virtue of parentage, and I'm talking about the father, for instance, is a British citizen, but the mother has nothing. And I mean, this is in quotes. I mean, so maybe the father is not looking after the child, and the mom is the sole carer for the child. The Secretary of State would previously take the point that, well, this child is British, you go away to your country, take the child with you. When this child is of age, the child is free to come back to the United Kingdom and exercise his or her British citizenship. But the European Court of Justice has come out and has said, no.
That's not the position.
If this child is going to leave the European Union, then that's not right at all.
Absolutely.
It doesn't strictly come within the discretionary leave provisions that we're looking at, according to the Home Office. The Home Office is going to be considering this under the regulations, under the EEA regulations. But at present, what we have is what is known as a policy to accept such applications, grant the mom, or as the case may be, it may be the dad.
Yes.
Maybe the mom has the child and said, oh, Dad, you have this child. I don't want to have anything to do with the child. So, you know, the Secretary of State will then, you know, give them a certificate of application, allowing them to work. So it's bringing the EEA regulations relatively, sort of in line with what we used to have under the immigration rules. Right.
I think it's a very much, you know, largely true in there in terms of the criteria here. You know, you did bring in a point. In the point you did say here, if I get from what you say, is in relation to this case law, some brand we're talking about. But the thing is that you just mentioned that this is the case law that are put up there, EU law, transported down, which we can apply that. Now, discretionary leave, you know, we all know, is that outside the rules.
Absolutely.
Now, standing alone on itself, the issue now, the question now is that this individual doesn't have a child who is British. Standing on his own and have lived here for a number of time. Obviously, we've pointed it out. It could be any years or months or days you spent in the UK. Now, the question is that can this person come out? And what are other criteria apart from the family now, which is very key, obviously, to deal with this matter. But these individuals don't have a family. Are there other criteria that individual can come in to make this application, those that are under this non-protective cases?
Absolutely. Yes, absolutely. The Secretary of State would take into consideration if there are medical factors, you know, that kicks in the discretionary provisions. And in that kind of case, you're looking at Article 3 of the European Convention. So that kicks in as well. Family is significant. That kicks in.
Definitely.
And, I mean, circumstances in that person's country also kicks in at some point. I mean, if there's a war going on or there's civil unrest, you know, or there have been a natural disaster, sometimes, you know, the Secretary of State may exercise discretion outside the immigration rules and grant discretionary leave. Fantastic. So, yeah, I think the point you're trying to make is that we should make it clear. It's not so much as you can only make an application and expected a grant on discretionary basis only if you have a child. No, that's not what we're trying to say.
It's wide.
It is absolutely wide.
It is wide. Ladies and gentlemen, it is wide. Discretionary leave application is very, very wide. And it, as I said, it's a discretion. The Secretary of State has got this enormous power granted and embedded in the office to decide who to give this discretionary leave or not. And some people try to say, let me make this application, who knows? Although there's a policy of which the Secretary of State must abide in terms of deciding discretionary leave application. But as I'm saying, it is discretion. It is at his pleasure of the Secretary of State to grant an application. We've come to deal with the fact that this application could come under the European Convention on Human Rights, which is very key to it. And also, it may also come out from the other aspects involving the individual. Article 3 is very key here. Article 8 is a family life, is very key here. And there are also the case laws that can back up this application. Ladies and gentlemen, this topic is wide. And whoever that is considering lodging this application, it makes sense. And it is advisable that you seek proper legal advice so that your circumstance can be properly harnessed and application lodged on your behalf. And that is why I've decided to put up this program, to educate you and to get you thinking, get you working, so that you can take action and take charge of your circumstance, needless to shout and scream, and you have no leave to remain, where there is a leeway of which you can make your application and remain in the United Kingdom. Ladies and gentlemen, it is very important that you understand that it's a wide area, so many issues could be taken into account, as Matthew have rightly stated out here, before considering it. There are case laws that can back your cases as well. That's the most important thing for you to understand. And we've just discussed that. I think, Matthew, you said something about